any reason you can't hear me, if something goes wrong, the screen goes blank, or you can't hear me, go ahead and ask a question, type it in your chat box, and I'll see it. Otherwise, I'll save questions for the very end. This webinar is being recorded, so you're on mute and no one can see who the attendees are. So I'll go ahead and get us started here. Okay, so my name is Tina Segura. I'm the staff attorney at the CLRC, the Cancer Legal Resource Center. So I want to just tell you a little bit about the CLRC and the services we provide, and then I'll give you a few legal tips that may benefit people with cancer who've been recently diagnosed. So what is the CLRC? Well, this is our mission to provide information and resources on cancer-related legal issues to cancer patients, survivors, caregivers, healthcare professionals, employers, and others coping with cancer. We are part of the Disability Rights Legal Center. And just as a quick overview of the CLRC, we generally don't provide direct representation or give legal advice. We focus more on the educational model in order to empower individuals with the knowledge of their rights under the law and to give referrals to other legal resources whenever necessary. We do have staff that speak English and Spanish, and of course our services are confidential. The CLRC operates a national telephone assistance line. The number on the screen here is our phone number. We gather detailed personal information about callers to be able to provide them with customized resources and information that may be pertinent to their issue. So our phone number is 866-843-2572, or if you forget that, 866-THE-CLRC. The quickest way, though, to get in touch with somebody on our assistance line is by filling out an intake form at clrcintake.org. That eliminates the phone tag and doing the initial intake. You can call to ask cancer-related legal questions for yourself or on behalf of someone else. What are exactly cancer-related legal issues? What might someone call or fill out an online intake about? With the CLRC, people may think, well, I just need time off of work. Is that something that I can call you about? Of course. What does the law have to do with it? Well, there are federal and state laws regarding medical leave and regarding discrimination in the workplace. So the following issues that are on the screen here: health insurance, employment, government benefits, landlord-tenant, immigration, real estate. These are some issues that people with cancer frequently face, and I'll touch on a few of these in our presentation today to just give you an overview of what the laws look like in some of these areas. So the CLRC exists to help you navigate some of these laws and provide you with resources and information regarding these issues, because as someone with cancer should be focused on the medical well-being, and oftentimes these legal issues sort of get forgotten about or can just be too confusing. So my goal today is, number one, just to let you know that we exist as a resource. The CLRC does exist, and again, it's nationwide and it's free. We don't charge for our services no matter what your income is. So we exist to help everyone, and some of the resources that we refer people to may depend on income. So we do ask what your income is when a person completes an intake with us, just so that we can be sure to match you up with the appropriate resources and not give you a resource that may be out of your income range for qualifying. So we do exist as a resource. We're free, and to let you know the types of things that might come up for a person who's been recently diagnosed with cancer. Many people don't know their rights and then find out about them when it's too late to do anything about it. So I'll give you a brief introduction today, and then I highly encourage you to contact us by phone or online for further assistance with your issue personally. So the first of the legal tips that I want to provide you with today is to know your rights in the workplace. For anyone who's still working, it's important to know that the following information that I'll be providing. So the main law that protects people against discrimination in the workplace is the ADA, the Americans with Disabilities Act. It's a federal law. The ADA um, prohibits discrimination against people with disabilities if you work for a qualifying employer of 15 or more employees, and if you have a qualifying disability. What's a disability under the ADA? And just as a key point, if you're seeking protection under any of the laws that help people with disabilities, it's important to know the definition of disability under each law because that does vary. So under the ADA, a disability is defined as a physical or mental impairment that substantially limits a major life activity. Under federal law, cancer can be considered a disability under that definition. And to be protected against discrimination in the workplace, you must still be able to perform the essential functions of the job with or without accommodations. So you can ask for reasonable accommodations in the workplace, which I'll go over in the next slide. But that's a basic overview of the Americans with Disabilities Act. So that law does exist to help people be protected against discrimination in the workplace if you have a qualifying disability. And under federal law, cancer can be a disability. Some states offer additional protection for people with disabilities. So the CLRC exists for you to contact us if you work in a certain state and want to know what your rights are in the workplace. You can contact us and we can provide you with the resources. But for instance, in a state like California, California's anti-discrimination law specifically defines cancer as a disability, and it protects people who work for employers of 5 or more employees. Unlike in the ADA, you have to work for an employer of 15 or more employees. So it is important to know generally the federal law that protects against disabilities, and then know that additionally some states provide even more protection against discrimination for people with disabilities. But many states just follow what the Americans with Disabilities Act says. Be sure to request accommodations before your work performance is affected. Why do I say this? Well, under the Americans with Disabilities Act and some state fair employment laws, you can request a reasonable accommodation in the workplace. What does that even mean? Well, it means that you can ask for an adjustment or modification in the workplace that might help you do your job. The Americans with Disabilities Act protects you, but you must still be able to perform the essential functions of the job, with or without accommodations. What the essential functions of the job are vary by trade. So for example, if you are a cashier who stands on your job and you experience fatigue, you can ask for a chair to take breaks, or you can ask for a modified schedule. But it's likely that an essential job function of a cashier is to be able to show up in person and to be able to use a cash register. So as you may have guessed by the name, a reasonable accommodation must be considered reasonable. That is, if you request a modification in the workplace to be able to do your job, it has to be reasonable. An employer doesn't need to grant the accommodation request if it's considered an undue hardship to the employer. This could mean cost or time or effort. And in some states, they spell out what the amount, what the monetary amount is that's considered an undue hardship. So you can request a reasonable accommodation. If the request is reasonable, then the employer is likely supposed to grant it. So although the laws like the Americans with Disabilities Act and state fair employment laws may protect people with cancer against discrimination, employers are not prohibited from taking negative action against an employee if their work performance is suffering or if they can't perform the essential functions of the job and the employer doesn't know about their need for accommodation. So generally it's the responsibility of the employee to ask for changes in the work environment before their work suffers. So if an employer starts to see you falling asleep at your desk, or you coming in late, or you're not able to perform your job and they don't know about an illness or they don't know about a need for accommodation, they can terminate a person even if they have a disability. They can legally terminate someone whose performance is suffering, but if you've talk to your employer and let them know that you have a disability that requires some reasonable accommodation, then they've been put on notice that you have an illness and that you need some sort of accommodation. So for that reason, we suggest to request accommodations at work before performance is affected, because the ADA protects people against discrimination, not from being terminated for performance reasons. So when you request accommodations, you may have to disclose enough about your disability to get an accommodation, just something that shows that you have a medical need for it, but you are not required to disclose your diagnosis as cancer. Some folks may have a great relationship with their work and may feel comfortable disclosing this information, but not everyone does. At the CLRC, we can provide more precise guidance on requesting accommodations if you'd like. And we even have a template that we send to people that we've gotten feedback from people who have said that they've successfully used our reasonable accommodations template. Not everyone is comfortable asking for an accommodation in the workplace, so we have this handy template that people use, so you can contact the CLRC by phone or online intake to ask for more information about this. Okay, another, another legal tip is that one of the workplace rights that you might have is the right to medical leave. So the Family Medical Leave Act, FMLA, is, I spoke about the ADA and reasonable accommodations, but I also wanted to go over leave time. So the Family Medical Leave Act, otherwise known as FMLA, is a federal law that gives you the right to take time off with continued health benefits to take care of yourself or a covered family member for up to 12 weeks. Covered family members are limited, but you can take time off to take care of parents, children, or a spouse. And we'll talk more about caregiver benefits on our August 24th webinar. So I mentioned that this webinar is part of a series, and at the end of my lecture today, I'll leave up a screen that says when our next webinars are, but we're going to have a webinar about caregiver benefits on August 24th. So, but just to let you know that caregivers can take time off to take care of an ill family member for up to 12 weeks. FMLA is unpaid leave where your job must remain protected and insurance benefits have to continue to be covered in the same way that they were while you were working. So these 12 weeks can be taken intermittently. They can be taken off a few days here or a week here, or all at once. It may not make sense for everybody to take 12 straight weeks off. Others may need that. So FMLA is up to 12 weeks of unpaid leave from your job. And not all employers have to provide FMLA leave. Government employers and private employers of 50 or more employees within a 75-mile radius have to provide FMLA leave for their employees. And in order to be eligible, you must have worked a total of 12 months. It doesn't have to have been consecutive as long as it all adds up to 12 months. So if you've worked certain holidays, seasonally, if it adds up to 12 months, then you'd be eligible. And you have to have worked 1,250 hours in the last year, which averages to about 24 hours a week, so that part-time employees qualify for this leave too. So 12 months, 1,250 hours, and 12 weeks. 12, 12, 12 is how I remember it. if you don't think that you qualify for FMLA, you're not necessarily out of luck with leave time. Or if you qualify for FMLA and you may need more than the 12 weeks, you're not necessarily out of luck either. So you can ask for leave time as a reasonable accommodation. Remember, we just talked about that. The ADA allows for you to ask for reasonable accommodation um, under under the federal law. So for some employers, it may be considered reasonable to allow you to take leave time under the Americans with Disabilities Act. If it's reasonable for the employer, then they can provide you with leave time either in addition to FMLA or as instead of FMLA if you're not qualified. So if you do need additional leave time beyond the 12 weeks that FMLA allows, asking for an indefinite period of leave time may be more likely to be considered an undue hardship on the employer than asking for a set period of time. Of course, not everyone has a definite return to work date, but if you're considering asking for additional leave time from your employer, you may just want to keep in mind that asking them to keep your job held open for indefinitely may be considered undue hardship on the employer, and they may say, sorry, we can't grant that accommodation. But if you need additional leave time and you know that it'll be at least 2 weeks or 3 weeks or even 6 or whatever the case may be, asking for a set amount of time usually helps justify that your accommodation request is actually reasonable. Finally, if you need some leave time and you're not sure what your work policy is, check the employee handbook to see what the company policy is on sick leave. Some employers have a really generous medical leave policy. I've heard up to 2 years from some employers. So just check your employer handbook because a lot of times some may have a more generous leave time than FMLA, but a lot of times it's 12 weeks, or if they don't have anything in their policy, then you should know your rights on FMLA. Okay, moving along to the second of the 5 legal tips. Strategize finances. Cancer treatment is obviously very expensive, and even for those who have insurance or have jobs, it's still a struggle to pay living expenses and the cost of treatment, and debt can easily accumulate. So one important thing to do is understand which types of bills are more important to prioritize. For many people, a car and a place to live are imperative, so those bills might be prioritized over unsecured debt like credit card bills or even medical bills. Landlords might have to make some accommodation for people with disabilities, but foregoing rent, unfortunately, is not one of those. Non-payment of rent can be grounds for an eviction, and a landlord can potentially start the eviction process fairly shortly after missed rent. Landlord-tenant law varies by state, and we have resources available for people with specific landlord-tenant questions. For property owners, as you know, timely payments are essential because if someone fails to pay their mortgage or car payment, the house could go into foreclosure or the car could be repossessed. We also have some resources available regarding foreclosure prevention for homeowners, so that's one of those things you can contact us about as well. One other thing to know is along these lines that as a consumer, you have a right to be free from harassment from debt collectors. There's a difference between debtors and collectors. Debt collectors, there are laws that protect people against unfair debt collection practices, which we can advise you on if you're not sure if a collector is wrongful in how much they're calling you or when they're calling you. You can contact us about that. We also can guide people on how to negotiate debt or how to look for medical billing errors. We have some referrals to other agencies and professionals who might be able to help with that as well. So if you think you might have a medical billing error and you're not sure how to go about it, that's one of the things you can contact the CLRC about for individual guidance. Okay, and along the finances line, finances lines, I wanted to go over some disability insurance options. One way to get ahead of debt is to determine your eligibility for disability pay. Leave time from work. I mentioned the FMLA and the ADA as ways to get time off of work, but that doesn't necessarily come with pay. In fact, leave time under FMLA is unpaid. Social Security benefits, private disability, and state disability are some of the options available to people with cancer. SSI and SSDI are two long-term disability programs available through the Social Security Administration. Both have the same definition of disability due to a physical or mental impairment that's expected to last a year or more or result in death. You're unable to earn substantial gainful activity. Basically, it boils down to you cannot work for a year or more. Just want to highlight some of the differences between SSI and SSDI. SSI stands for Supplemental Security Income. That's based on income and resources. So if you are low income and you're an individual who owns less than $2,000 in resources, or you're a married couple who owns less than $3,000 in resources, then you may qualify. What do I mean by resources? The things you own, bank accounts, possessions, excluding one house and one car when counting resources. The Social Security Administration assumes you need at least one of those things, so they exclude that in your count of $2,000 or $3,000. So that's SSI in a nutshell. SSDI, which is Social Security Disability Insurance, that's available if you're quote unquote insured, meaning that you've earned enough work credits, you've worked 5 out of the last 10 years. Now just note that with SSDI, there's a 5-month wait period. You won't see a check till your 6th full month of disability, so it's beneficial to apply as soon as possible. Payments are retroactive back to the date your disability began, up to 12 months before the date of your application. And some people apply for both at the same time. You can get SSI payments while you're waiting for your SSDI payment. And then as far as state disability insurance, only a few states offer state short-term disability. For example, California is one of the few. You may qualify for state short-term disability. If you don't live in California, call us for information on your state's disability plans, because not all states offer state short-term disability, unfortunately. So one option that people often elect is private disability insurance. It's one that private disability insurance, as the name implies, it's private. Either you've purchased it on your own, or sometimes employers provide their employees with disability insurance. The eligibility requirements all vary by policy. So the eligibility requirements are written out in these policies, could be short or long-term disability. Okay, moving on to the third tip. Excuse me. Know your insurance options. So if you don't have health insurance, here are some of the options that exist. The first of which is COBRA. This is a federal law that provides for continuation of coverage. You may have heard of it before. It's expensive, but it's an option that many people elect that allows you to keep your same insurance. For some people, it may be the best option if you're currently going through treatment and you don't want to switch doctors and go through the process of getting new insurance. You can qualify for COBRA if you work for an employer with 20 or more employees, and depending on the reason for losing coverage, you can keep your insurance under COBRA, your same health insurance, for 18 up to 36 months. If you've lost your job or your hours are reduced, you'd get COBRA for 18 months. Otherwise, it would be 36 months. And again, if you have specific questions on your particular eligibility for COBRA, you want to know if you might be eligible under your spouse's COBRA plan, you can contact us and we'll go over your individual scenario. But just know it's somewhere between 18 and 36 months of coverage. Of course, you can pay more than 100% of the premium. You could pay 102% of the premium, and that's federal COBRA. Every state, not every state, some states have laws that are similar to COBRA that apply to employers with fewer than 20 employees. So I mentioned that COBRA is an option if you work for an employer with 20 or more employees, but what if you don't? So for some states, if you work for a smaller employer, or if your employer is 20 or more and you want to extend your COBRA coverage, some states have we call mini COBRA laws that allow people who may not qualify for COBRA or who need extension of COBRA to qualify. So again, contact us for information about your state-specific COBRA laws. COBRA, as most people know it, is the federal law, and just wanted to point out that some states have a mini COBRA law too. Of course, in some states that do have it, for instance in California, you could be responsible for paying up to 110% of the premiums. So again, it is a little bit more expensive, but it is an option for some people who can't go through the process of switching their insurance and just need to continue on with coverage. Okay, and finally, marketplace insurance. You may have heard of the Affordable Care Act. So this is one of those things under the Affordable Care Act. If you're not eligible for COBRA or a state law equivalent, you might be eligible for a special enrollment period to purchase insurance through your state or federal marketplace. So you can purchase a plan on the exchange during open enrollment, which is usually November 1st through January 31st. Or if you miss that window, you could qualify for a special enrollment, meaning within 60 days of a qualifying event, you can enroll in the marketplace to purchase insurance. What are qualifying events? For example, it could be getting married, divorced, having a child, turning 26, because under the Affordable Care Act, children can qualify for insurance under their parents' plan up to age 26. But if you age out of that plan, you may qualify for a special enrollment if you move to a new state. So these are things that if you act within 60 days, you can qualify for a special enrollment period. Okay, and when you do have insurance, it's really important to understand what your health insurance covered. What your health insurance covers, unfortunately, our doctors, surgeons, and nurses, our treating practitioners don't often know what's covered under our insurance plans and what isn't, or to what extent. So even if a patient or a doctor calls the insurance company beforehand, an insurance company could later still deny payment if it isn't specifically spelled out in the policy that it's something that's covered. So it's always a good idea to become intimately familiar with your insurance plan so that you understand your co-pays, deductibles, and networks. Basically, know your policy well. Even if you have a PPO, you want to make sure that the doctor you'd like to see is in-network. The insurance company should have a list of in-network doctors, but this is important because a visit to an in-network doctor might cost you, for example, a $20 copay. But an out-of-network doctor could mean that you'd be responsible for co-insurance, which means you might have to pay 50% of whatever the doctor bills, which is anyone's guess as to how much that would be. Simply saying, I didn't know that wasn't covered, doesn't often help people win appeals. Knowing what your plan covers greatly helps prevent unforeseen costs. Insurance companies are in the business of making money, so if you accidentally go to an out-of-network provider, You're usually the one blamed and liable for paying the bill, not the doctor. Um, Knowing what's on your plan can really help because when you get a bill, if you see something on there that you know should have been covered, you'll know right away to make that phone call to the doctor's office and say, hey, my insurance company is supposed to cover this. What went wrong? Maybe it was a billing code that was just typed in wrong. Maybe it's something that you know should be covered, in which case you want to file an appeal. So before I move into that, the CLRC has some helpful documents and information so that you can appeal a denial when your insurance company doesn't pay for something it should. But unfortunately, many people don't know what's on their plan, don't know what their plan is supposed to cover, and so they end up paying these bills that they get just thinking that that must be what they owe. So again, understand your insurance coverage so that you know what to appeal. All right, moving into health insurance appeals. So how do you know what your plan is supposed to cover? The summary plan description usually has information on what is covered, how many of certain visits are covered. Um, you can look for the evidence of coverage booklet to determine what benefits you're entitled to, and also to determine the proper process for filing an appeal. If you file a claim and the insurance company sends a denial letter, you'd use that to determine the process for filing an appeal. So it's either spelled out in your plan or the insurance company will send the process to you in their denial letter. An appeal usually involves writing a letter explaining why the services that were denied should be covered or reimbursed by your insurance plan. Under the Affordable Care Act, if your appeal is denied by the insurance company, you might have the right to external review, also known as an external appeal, also known as an independent medical review. So there are time limits to file an external review, and depending on what type of insurance plan you have, there are also different processes to filing that external review. You can call the CLRC to find out if the health issuers in your state follow a state-run external review process or if they participate in the Health and Human Services administered federal external review process. So just a caveat, this part of the Affordable Care Act doesn't apply to grandfathered health insurance plans. If your plan was created or purchased prior to March 23rd of 2010 without significant changes, it might be grandfathered and these laws wouldn't apply. Unfortunately, grandfathered self-insurance plans do not have access to external appeal. How do you know if your plan is grandfathered? Well, you're supposed to receive notice from your insurance company. But anyway, just to summarize, know your plan, figure out the proper process for appeal and the deadline. You can file an internal complaint or an internal appeal. That's the standard way of filing an appeal with the insurance company. If the insurance company denies it and says, sorry, we're not paying it, and you've exhausted internal remedies, you may be eligible for an external appeal, a review by an independent company that isn't your insurance company that's supposed to review your insurance company's decision. So there's a lot to know in that process, so please don't be afraid to contact the CLRC if you run into a case where you need to file an insurance appeal and you're not sure whether you should file an external appeal, but you will become very familiar with your insurance plan and know what it covers so that you can know when you should be appealing. So I'll move on, but just know that in addition to if you contact us online or by phone, we can guide you through the process. I'm just doing a quick overview today so that you're aware of the things to look for. And we encourage you to contact us for more details so that we can give you state-specific information. All right, the fourth of the 5 legal tips in this series. Tip number 4, don't just talk about your wishes, document them. Everyone should have a plan in place regardless of current health status. So to ensure your wishes are upheld and to make decisions easier on loved ones, make sure these documents are created before they're needed. Even if you're comfortable talking about death, you may not realize how important it is to have your wishes written down in official documents like the Advanced Healthcare Directives, Power of Attorney, wills, and or trusts. Make sure you have a financial power of attorney and other documents prepared ahead of time. Serious issues can present themselves if a person becomes incapacitated or dies without any of these official documents. These serious issues can be prevented if you document your wishes ahead of time. If doctors need someone to make medical decisions on your behalf, think about that one person you would not want to make decisions for you. Well, the doctor or judge may turn to someone who you'd rather not have put in charge of your medical decisions, or the person may not know what your wishes would be, or the person may feel really uncomfortable making those decisions, or may be pressured by family members and other loved ones. So because all of these issues could present themselves, should a person become incapacitated or unable to make medical decisions on their own, it's really important to have these wishes documented. You may have said some things out loud to family members, but people forget, or in times of stress, or if family members have conflicts, it's really just important to have it documented. So there are a lot of free forms available online, and the CLRC can help guide you so that you know what you might need. Our August 10th webinar is going to go over more detailed information about estate planning. Again, this is part of the summer series, so one of the webinars in our summer series will go over some more detailed information about estate planning. That webinar is going to be, like I said, August 10th, and it's called 5 Legal Tips for Advanced Stage Cancer Patients. But regardless of an individual's prognosis, advanced stage or not, we'll go over things like wills and trusts, conservatorship, advance directive for healthcare. We'll also talk about the implementation of the Death with Dignity law in California and other states, and we will talk about other end-of-life treatment options. If you can't attend on that day, this webinar and that webinar as well, all of our webinars are posted on our website after they're presented. So we'll have it up on our website shortly after that date for you to watch at any time. So I highly recommend to watch that webinar. And then again, you can contact us if you're wondering what exactly is a power of attorney, what do I need in an advanced healthcare directives, how do I write a will in my state? Every state has different requirements to make a will valid, how to make a valid trust. You may be wondering which is a better option. We can connect you to some specific estate planning attorneys who might be able to help sit down with you, help you review your documents. But in any case, just this webinar is just, at this point, I just want to, if I haven't already done so, just stress the importance of having your wishes documented and the things you might want to look for. And again, if you have specific questions about how to make certain documents or which documents you may need or attorneys in your area, please do contact us by phone or filling out the online intake and answer some brief questions so that we can connect you with the right resources so that you can do some advanced planning. And of course, mark your calendars, August 10th, the advanced planning webinar for the CLRC will be taking place. All right. Moving along to tip number 5, coming to close to an end here to our webinar. Tip number 5, don't take no for an answer. This applies to many of the issues that cancer patients face, but most importantly to insurance denials and Social Security disability applications. When a person can no longer work due to a disability, they begin to look for other means to support themselves and their family. Oftentimes people apply for SSI, which is, as I've discussed before, Supplemental Security Income, or SSDI, Social Security Disability Insurance. A lot of times when people apply for these benefits, they're denied. Um, we always encourage people to appeal if they think their disability will prevent them from working for a year or more. Unfortunately, the Social Security system is set up to deny people their first time around. So people tend to do better when they appeal their initial denial. I can't recall the exact statistic, but it's somewhere over 50% of people who appeal a denial are later approved. So not only does an appeal provide people with the opportunity to present additional evidence of their inability to work, but also potentially provides them with support, with the opportunity to plead their case, usually with the assistance of an attorney, in front of an administrative law judge. So the appeals process for the Social Security Administration, and just to back up a second, the Social Security Administration oversees both SSI and SSDI programs, and when you are initially filing an application, it's best to do so online, ssa.gov. The Social Security Administration used to send people a statement every year of your Social Security. It would say things like, for example, this is how much money you would get in your Social Security retirement. This is how much money you would get as your monthly benefit. But now Social Security has stopped sending that, and instead you go online and you fill out a short profile questionnaire, and you create a profile on ssa.gov. I did it about a month ago, and was able to log in really easy and see a Social Security statement. So we encourage people to go on ssa.gov to see what benefits you might be entitled to, and also to fill out an initial application. Usually an initial application is best done online. No need to go in person. If you're denied, as the tip number 5 says, don't take no for an answer, file an appeal. You can contact the CLRC right away if you should be denied. Hope not, but if you are, contact the CLRC and we can provide some information and resources on how to go about a Social Security appeal. And there are different processes depending on what level of appeals you're at. The appeals process, like I said, has 5 levels of appeals, and there are very specific deadlines to appeal the Social Security Administration's decisions. Usually the appeals must be done within 60 days. We usually advise people to just make sure you open all mail because you don't want to miss any deadlines. This applies for Social Security, for insurance, or otherwise. Additionally, talk to your medical team so that the medical records actually reflect your inability to work. So for example, a person may go to a doctor's visit and may talk about how they had a great day and they were able to do some exercise. Well, if the doctor documents that and says patient's doing great and physical activity, makes some other notes, the Social Security Administration later requests medical records from doctors, well, it may not reflect your inability to work. So if you're planning on filing for any sort of disability insurance, make sure you talk to your doctors that are treating you and let them know you're planning on filing for disability insurance. Let them know you're planning on getting some Social Security benefits so that they can accurately reflect in their medical records that you have the inability to work. Doctors usually know what to put in the note, so you just want to work with your medical team and let them know if you're planning on filing for any sort of benefits. So the Social Security appeals process is supposed to be non-adversarial, meaning it's supposed to be easy for you to go in without an attorney, but oftentimes people do hire attorneys to help with appeals. For Social Security disability lawyers, and you can contact the CLRC for some referrals. The fee is limited to 25% of the past due benefits you're awarded, up to a maximum of $6,000. Note that the attorney will be paid only out of your past due benefits or your back pay. So if you're interested in hiring an attorney to help with an appeal, again, you can contact the CLRC and we can provide you with some referrals depending on what state you're in. And I'd like to just remind you here that the CLRC, the Cancer Legal Resource Center, we have some attorneys on our professional panel. These are attorneys who are familiar with the CLRC and have agreed to provide our callers with a free 30-minute consult. So in some places we have professional panel attorneys who've agreed to help our callers with certain matters. So you can contact us for referrals to legal aids or other organizations or sometimes professional panel attorneys, depending on the area of practice and depending on the area that you live. So again, don't be hesitant to contact us. So don't take no for an answer. And just to let you know, of course, this webinar that I'm presenting will be later posted on our website. I'll end the recording as soon as I'm done talking so that I can answer questions, but only the webinar that I'm presenting will be online shortly after it's presented. We offer webinars, of course, for individuals and their families and for professionals. We keep these webinars on our website for you to access even long after they're presented. So I wanted to just point out our calendar here. Our next webinars that we will be having are as follows. These are the rest of the webinars in our summer webinar series. So the 5 legal tips for young adult cancer patients. This is where we'll talk about the types of protections available to higher education students with cancer, including possible discharge of student loans and including applying for jobs with a history of cancer. Our August 10th webinar will be the 5 legal tips for advanced stage cancer patients. I mentioned this one earlier on, and this is where you'd learn about advanced planning, SSI, SSDI. I didn't talk about compassionate allowances, but that's something for advanced stage cancer patients to be aware of. And they'll go over that in the 5 legal tips on August 10th. Advanced healthcare directives, we'll talk a little bit more in detail about that, and other things you can do to ensure that your wishes are upheld. Our August 24th webinar is where we'll talk about the tips for caregivers. I mentioned that one as well. The Family Medical Leave Act, FMLA, which I touched on earlier. We'll talk about options for taking time off of work, along with other benefits available to caregivers of people with cancer. Cancer is a family disease that affects everyone, so you know, I went over some of the information to know about if a person's been recently diagnosed, but caregivers often want to know what they should be aware of too. So we have a webinar dedicated to the caregivers, and that'll be on August 24th. If you can't make any of these, they'll all be from 12 to 1, hopefully during people's lunch breaks. We try to accommodate. If you can't make any of these, then you can just go on our website. Sometime shortly after that, they'll be posted up there. Also on our website, we keep a variety of educational handouts that we update as often as possible. We also have a patient legal handbook available to cancer patients and their families to have as a reference guide for your basic legal rights as they relate to cancer. This patient legal handbook contains information on some of the legal issues that I introduced to you today, such as anti-discrimination laws, how to access health coverage, wage replacement options, and estate planning. I went over all of these topics just in brevity so that you would have an idea of laws that exist and the services that we provide to give you more details. But this patient legal handbook that's available for download in English and in Spanish, that is sort of an overview if you need something printed. It's hard to go over all of this information in 1 hour without overwhelming you, but if you need the information to pass along to one of your family members or friends or another person who may benefit from it, you can go online and download it for free. Spanish also available for download I mentioned, PDF version so you can email it to people who may need it too. We also have a similar handbook intended for professionals, including oncologists, called the Healthcare Professional Manual. That's on our website as well and is currently being updated to include some of the latest information. I think that was all that I wanted to mention. If there are any questions, I'll keep my chat box open for a few minutes. I'm going to go ahead and end the recording now. If you have questions, I'll go ahead and answer them. I'll stay online for another few minutes and answer whatever questions that you may have. Thank you so much for your patience and for attending today.